Welcome to the Getting the Deal Done podcast. This is John Martinka, and my very special guest today is my friend Michelle Bomberger with Equinox Business Law in Bellevue, Washington. And we are going to talk today about something every business owner should at least know and understand, and that is what's going on with things like non-compete agreements and related. And Michelle, we know the Biden administration has got a proposal out there to eliminate pretty much all non-compete agreements. The state of Washington and other states are really clamping down. So let's talk about non-compete agreements to start.
Yeah,
What's
thanks,
going
John, for
on?
having me. Yeah, it's a very rapid and impactful change that we're seeing. So a lot of people who, if you followed this, most people know that, with California, just don't bother. Non-competes are not a thing, can't really enforce them at all. And then you've seen some of these more, employee progressive states, such as Washington, Oregon, Colorado, New York, that have implemented their own laws that basically just tighten up when a non-compete can be used. And we'll talk a little bit more about the details of that, but just from a framework standpoint. So each state has their own basic rules, and those rules, of course, are different in each state. And then we have this new federal ban that is proposed. We expect to have some more information on whether it will move forward in the next couple of weeks. It's set to take effect on September the 4th, but it is in the middle of some legal challenges. And so we don't know for sure whether that will happen. So I think just the big landscape is understanding that there's all this state stuff, you've got the federal stuff, and then on top of that, even if the federal stuff goes into effect, there are nuances in the state laws that will still have to be followed as well.
Okay. So let's look at it from the perspective of a business owner, someone who's got a company with 20, 40, 60 employees. And, a lot of them are workers. Some of them are management. Some of them are sales and, or maybe the engineer with some of the secret sauce that they work with.
Yeah, absolutely. So if you still have non-competes in your agreements, and we'll start with Washington because you and I are both in Washington, so we'll just kind of start with that as a starting point. In Washington, a few years back, they implemented the non-compete restriction that says employees must make over a certain salary threshold to be eligible to be held to a non-compete. This year, that number is 120,560. So anyone who makes less than that, you can't have a non-compete for at all, period. So that's kind of the first element. In Washington, this also applies to contractors. So that is a unique thing that we spent so long trying to get folks to distinguish between contractors and employees. And so they bucketed them all together in this law, which is, again, a little bit challenging to navigate, but it's not the wrong decision. It's just challenging to navigate. The other thing that's really important in Washington is there was an amendment that just took effect on June the 6th of 2024. And that also addresses non-solicitations. So clarification on the difference, a non-compete is when the employee is restricted from working for a competitor. They can't go and work for the business down the street that does the same thing. A non-solicitation is restricting the employee from reaching out to customers or reaching out to employees and soliciting those folks to leave that business and come work for another company. Those often get confused. And so those are two different things. So Washington has this non-compete. It's a threshold of salary, and then the non-solicitation has also been tightened up in this new amendment.
Okay. So if I have a salesperson and let's just say they're making 200,000 a year and I can have a non-compete, I can have a non-solicitation. Now, I've also heard over the years you can't prevent someone from earning a living in, their chosen profession and where their skill set is.
Yeah, that's right. So the non-compete restrictions almost always have a reasonableness standard. So that's reasonable in geography, reasonable in breadth, and you can't have something so broad that it limits someone from being able to be gainfully employed. So that's kind of a standard across the board. In Washington, there are also, specifics around time, so it can't exceed 18 months. In other states, it might be 12 months. A lot of states, there's not an explicit number, but it is more the facts and circumstances around reasonableness of the restriction.
Okay. So again, that same salesperson, the non-solicitation would prevent them from poaching the employees from where they're leaving or going after the customers of their departing firm.
Correct. Now, something that's really interesting is when the non-compete restriction came into play a couple of years ago, what folks did in response was to broaden their non-solicitations, right? So when we think about why do businesses have a non-compete, right? We're trying to protect our confidential information. We're trying to protect our trade secrets. We're trying to protect our employees. We're trying to protect our customers, right? Trying to keep people from taking those things elsewhere. So what most of us did was to say, okay, instead of a non-compete, which says you can't go work at another business, let's buckle down on the non-solicitations. And so those non-solicitations became very, very broad. You cannot talk to, you cannot contact, you cannot service any customer, prospective customer, prior customer of our business ever, anywhere. Okay. So what Washington's done is to say, wait a minute, that's not okay. And so now the non-solicitation rules in Washington, and Washington is the only state, as far as I know, but there may be others, that has this, that says you can restrict them with respect to customers, not former customers, not prospective customers, not all the people in the world, customers. And so that's going to force people to really narrow that. You also can't prohibit them from working with the customer. You can prohibit them from soliciting them, but not from working with them. So again, there's some nuance here that really is going to force people to look at their non-solicitations and be careful about what are you trying to do? Be strategic about what are you trying to accomplish with this term and make sure that it does what you want it to do and not a whole lot more.
So if I've got a non-solicitation agreement that was put together a year and a half, 2 years ago, and they've changed the rules, if I don't change it to conform, does that make the whole thing null and void?
It's a great question. In Washington, they don't require you to notify the employees that the provision is not enforceable any longer. So the employees can sit there thinking that they still have this in place because you're not required to notify them. You just can't enforce it after the fact. And there are penalties to trying to enforce it after the fact. If we look at the federal ban, the proposed federal ban, and again, it doesn't deal with non-solicits, it deals with non-competes, it actually has a proactive requirement to notify people that their non-competes are no longer enforceable. So that's a lot of work for some companies. If you have a whole bunch of non-competes in place and you have to notify everybody that it's no longer enforceable, that's something you need to plan for.
Now, are there any limits on the federal law that may go into effect in a couple months? I mean, salary, exempt, non-exempt, etc.
Yeah, the one thing that remains is if you have a non-compete in place with someone who is a quote senior executive as defined under the law, those can remain in place. No new ones can be formed and all other ones go away. So looking at who you have that qualifies as a senior executive, the definition is 151 plus $1,000 per year in salary or earnings, and they are in a policy-making role. So those things are the categories that qualify someone as a senior executive, and those place. That's it.
Okay. So the salesperson making 3, 4, 500,000 wouldn't be able to have one because they're not policy making.
Right. So you'd have to think about is there digging into what that definition is, figuring out if you would want to change that change that role. And again, you don't want to put yourself in a position where they would be able to challenge it also. So it needs to be legit if you're going to do it.
Okay. So you told me, something about Oregon law and non-competes, and we'll get to that, but it applies to exempt employees. So define for everybody what's an exempt and what's a non-exempt employee.
Yeah, it's a really common question in a confusing space. So a lot of folks will think about exempt versus non-exempt as being salaried versus non-salaried, and that is not the standard. In order to be classified as an exempt employee, you must meet a certain category under both federal and state law. So understanding that there's a federal definition as well as a state definition, they're usually pretty close, but they also can be different. So you've got to pay attention to that. The classes or categories are professionals, administrative professionals, computer users. There's a couple of other ones. Those are the big ones that come to mind right away, but there's 4 or 5 categories. They have to meet not only a certain salary threshold, so they have to have be making a certain level of income, and they have to have managerial authority typically. They have to have a certain level of decision-making and authority, because what happens when someone is exempt is they aren't entitled to overtime, they aren't entitled to meal and rest breaks. And so the wage and hour rules that apply to them are different. And so the assumption is that they are of a management category, they are expected to work in a different way than non-exempt employees.
Yeah, and I get that. I mean, we've seen things in the news about fast food restaurants that had someone making 20 some thousand dollars. They said they were exempt as a manager and they could work 60 hours and not get overtime. And we
Yeah.
remember the headlines about sandwich franchises that were having people sign non-competes, like what are you going to take from Jimmy John's to Jersey Mike's or vice versa?
Yeah. And I'm glad that you brought that up, because I think as business owners, our instinct is often, we need these things. These things are important to protect our business. And when you look at kind of how they've been applied, sometimes there's not really a business protection there. There's simply a putting it in place because we can. And overall, this is good practice for business. This is good practice for employees to be able to go and better themselves where they really want to work. But it is hard as a business and an employer to, struggle with how do I protect my business without these things.
Yeah, you're right. So let's flip it around to buy sell deals. So let's start with owners, sellers, and what's enforceable and not enforceable. Has anything changed? So if I'm client is selling their business and the buyer doesn't want them competing, how does that look these days?
Yeah, generally speaking, it's still allowable. These laws are focused on the employer-worker relationships primarily. There are a couple of laws that explicitly call it out. Washington's law, for example, calls out that they are allowable in a business transaction so long as more than 1% of the business is being sold. And really what they're trying to do is not have a way that people work around these to say, oh, well, I gave you a little bit of equity and I'm now allowed to have a non-compete or something, along those
Yeah.
lines. Now, in a lot of deals, as you are aware, you may have a purchase agreement that has a non-compete. So the seller is agreeing not to compete with the buyer. And then you have an employment agreement. And under that employment agreement, they may not have a non-compete based on how much they're making and based on what the rules are of that particular state. And that's okay, right? You just got to think about what you're tying that non-compete to and making sure that it's consistent with the relationship that you're seeking to build.
Mm-hmm. So is the fact that the seller is being compensated, does that have any bearing on the fact they can do a non-compete?
No, it's mostly just that it's not an employer-employee or employee-worker relationship.
Okay. So, and you can clarify this because I know a number of years ago, uh, I heard, someone, I won't say I heard, but I was made aware of if an employee like if someone buys a business and they want the new employees, their new employees to sign a non-compete, and let's say they are salaried and exempt and make a certain amount of money, uh, that if they're compensated, it changes things versus if they don't compensate them at all.
So I think there's a difference between a new employee and an existing employee. So with a new employee, and let's assume that the federal ban is not in effect because that changes the dynamic entirely. There's no new non-competes at all if the federal ban takes effect. But just under Washington law, for example, if you are requiring a new employee to sign a non-compete, you have to give them a certain amount of notice before they come on board, before they sign. In Washington, it is no later than the acceptance of the job offer that they have to know about that non-compete. So you have to disclose it in advance. In other states, it's 2 weeks before they start. So every state again is going to look at its own laws. For a existing employee that doesn't have a non-compete in place and you want to add it, like maybe they just went over that threshold of salary and you want to add the non-compete, then there has to be some additional consideration, some additional compensation to pay them for that trade-off, right? You're asking them to give something up. And oftentimes, as I just suggested, is that if they're getting a salary increase, that may be sufficient consideration. It might be a job title, it might be a bonus, but you have to give them something in exchange for that restriction.
So let me put you on the spot. How do you think all of these rules are going to end up affecting, what we work in the lower middle market and their businesses, those businesses?
Yeah, I mean, I think what we're seeing is an increasing pressure and demand for transparency by businesses. So things that we used to rely upon to protect us, people didn't know about what everybody else in the company was making. They didn't know what the benefits were. They didn't know that bad things were happening because we had these, settlement agreements and NDAs. All those things are kind of going away with the shift toward employee protections, employee rights, and more disclosure. So pay equity is a good example. We now, in many states, are required to disclose pay range and benefits. And so now your current employees see what's out there, right? In Washington, we have Silence No More, which says you can have an NDA, but you can't prohibit someone from talking about bad things that the employer's done, things like assault and harassment. And so I think this pressure is creating an administrative burden is one thing, right? So now we have to make sure that we are putting those job postings out there properly. We're making sure that we've got compliance. And in addition to that administrative burden, I think what we're seeing is the fact that there's more demand by not only the regulators, but also other stakeholders. So your employees want more information. Your vendors might want more information because that information is now expected to be public. And I think those are hard things for us to swallow in the smaller business categories.
Okay. So when it comes to non-competes, non-solicitation, exempt, non-exempt, all of that whole basket of things, what are your top recommendations for your clients right now and what they should be doing? Not necessarily that they are right now, as we know, but they really should. What should they have in order?
Yeah, so exempt, non-exempt is not new, right? This is something that's out there, and it's something that is a very common error that people make. So really understanding what that means and how you're applying it to your employees. If you're audited, it's gonna be a mess if you don't have that proper. I've heard stories about folks who there's an employee who is classified as exempt. They know that they're not exempt and they're just tracking their overtime so that when they go to leave, they can kind of create that bill and that liability for the employer. I don't think that's everybody. It's hopefully not the majority, but that's the kind of stuff that you want to be aware of what it is so you can do it right and you don't put yourself in that position. With respect to the non-compete, non-solicitation rule, so Washington's non-solicitation rule just took effect And it's not going to go away even if the federal ban happens. So you need to look at what you have in your agreements and certainly fix them for any new people coming on board. That's important so that you're not putting new ones out there that are violating. On the non-compete front, that is something that, again, we have a question mark on what's going to happen and when it's going to happen. So inventorying what you have and understanding how the federal law would impact the notices that you would need to give. If you have 50 people you need to notify about this, you need to be prepared to do that before September the 4th. And so now is a really good time to do that inventory. But a bigger picture item is, employment is just, it's moving so quickly. And especially if you're in a multi-state environment where you have employees in multiple states, you need to find a way to stay on top of the changes. So whether that's getting newsletters from SHRM, which is the Society of HR Managers, whether having a HR firm or a law firm that's giving you updates, find a tool, whatever works best for you, to ensure that you know what's happening, and then make sure that you've got someone on your team who's proactively implementing those changes.
So with all that's going on, is it still possible for a business to protect their trade secrets, their customers, etc.? Or is it pretty much going away?
Well, it's a good question. As I mentioned, I think you still have confidentiality provisions, you still have non-solicitation provisions, you still have non-interference provisions. You just have to be careful with what they say, right? And I think where the opportunity is to look at that confidentiality provision that you have in your employment documents and say, is it doing what it needs to do? Does it actually address the important things? And what most people have is that kitchen sink language. It's like, processes and patents and, business development plans and customers. Like, it's just kitchen sink language. But does it actually have what you care about in there? Because when push comes to shove, that's what you want to be able to cover. And then how can you make it actionable, right? How do you know if someone takes that confidential information and goes somewhere else with it? That's the hard part, is how do you know when that happens? Because you don't know what they're doing at their new job. So trying to figure out how you can make it actionable. And then I would be really careful with the term trade secrets, right? So something that is a trade secret is not something that everybody in the company knows, right? Otherwise, it's not a secret. So the Coca-Cola, recipe, the KFC, herbs and spices, those are secrets. So if there's something that is the secret sauce of your business, it shouldn't be something that everybody knows. It should be very carefully guarded. And then those people hopefully are the ones that still have non-competes or confidentiality agreements that really tighten up those pieces.
Okay. I got one more question. I'm going to go back to something you said early in the discussion, and you mentioned the non-competes in Washington, contractors versus employees. So what's going on with contractors, classification of their, people want to say, oh, they're a contractor, then I don't have to pay FICA, Medicare, unemployment, L&I. I just saw a company and the owner was paying everybody as a contractor, which for some of the, professionals that were outsourced, yeah, it could make sense because they had their own businesses and got their own business other places. But people who are doing the billing, that you're telling them what to do, when to do it, how to do it.
Yep,
That I always
it's a
thought makes one
question.
employee.
Yeah, it continues to be a challenge because you're right. The mindset is it's so much easier just to have them as a contractor, right? That's just the general mindset. The challenge is that the law will default them to an employee. That's the starting point. They are an employee. You have to overcome that presumption. And the standards for what is a contractor are becoming more and more rigid. And overcoming that presumption is becoming more difficult. So you mentioned, direction and control. That's kind of the starting point as a standard. Are you telling them where to be, how to do their job? You're training them, you're giving them all the facilities. That's an employee. Similarly, and I think one of the most important threshold issues is, are they a business? I was told once by L&I that the first thing they do is go through and look for checks written to employees. Look for checks written to individuals. because a check written to an individual is going to be suspect in a business environment. And a lot of contractors are set up as individuals, and those checks are written to those individuals. That is not a contractor. A contractor is someone who runs their own business doing this work for other people. And if they're only working for you and they don't have a business, they're not a contractor. They're never going to overcome that standard. So being really aware of the fact that the default is an employee, period. That's where they will default both the federal and at the state level. And then you need to be able to prove that these things are true, that they're meeting the standard for a contractor.
Okay. Any final thoughts on these subjects?
There's a lot going on. I don't think employment is going to slow down. And again, the multi-state issue is becoming even more complicated. So if you don't have someone kind of paying attention to this for you, I would find that person in your company or an advisor to your company who can keep you safe. And I should have mentioned this at the top of the call, but this is obviously not legal advice. This is information. You should certainly talk to somebody who's close to your situation, who knows your business, before you take any action relating to any of this, because it is nuanced and it is complicated.
Okay. So you had mentioned when we were doing the prelim for this podcast about some information you have that you can share with others. What's the best way for them to get that?
Yeah, so we have a matrix that we put together with certain states that we commonly work with, and some of the non-compete laws as well as the federal law. So in order to get that matrix, feel free to reach out to me. It's michelle@equinoxbusinesslaw.com. We will also try to put a link to that in the show notes if we're able to do that. You can also take our business health assessment. That's on our website, equinox.law. And that is about a 5-minute survey assessment. And you get a 30-page report that helps you to think about the different parts of your business and how you're doing in each of those areas.
Okay. Well, Michelle, thank you. She just gave everybody her contact info. Well, it also is going to be in the description of this conversation. So thank you very much. This was highly informative and obviously very timely with what's going on.
Thanks, John.
All right.